Hey everyone, I'm Janis with Real Estate Closing Path, and I'm so excited to visit today with Marc Enzi with Tax Solutions. And he's our expert here, going to talk us through all that we ever needed to know about FIRPTA. Marc, I'm excited to have this conversation with you today. Thank you.
Thank you, Janis. Appreciate you having me.
Yeah. Would you tell us first a little bit about your background? How did you get started in this industry?
Right. My name is Marc Enzi. I'm a certified financial planner and enrolled agent. I'm licensed by Treasury, U.S. Treasury, to represent people in federal tax matters. And my niche specialization is international tax. And then further niching down, drilling down, it's foreign sellers of U.S. real estate. So I work in the intersection between the tax world and real estate world. And where those two meet, we get an interesting thing that comes up. It's called the Foreign Investment Real Property Tax Act, super specialized. And most people have no idea what this is. They never come across it. But when they do come across it, all of a sudden, it creates some concern and confusion and misunderstanding and apprehension. And deals can fall apart at the closing table if this is not understood. And it's often misunderstood. So I've been doing this since I think 2004. Yeah, so we've been doing this for 20 years, and yeah, not going on 21 years. And I've spent time working at Price Waterhouse as an international tax manager, and then went into private practice. And I've been working on my own in private practice since 2009. And we've always specialized in international. And then over the years, we've really niched down. And so now we concentrate on, we still do individual tax work, but the bulk of our practice is FIRPTA, foreign sellers of U.S. real estate. And then we also handle some tax controversy. That's where there's an argument between IRS and the taxpayer on, the amount of tax owed, and then also how much the taxpayer can pay. And so whenever those conflicts arise, we get quite a few of those with FIRPTA. Especially with penalty cases. We do a lot of penalty abatement cases. And then we also recover the FIRPTA deposit. So we bring in all three areas. So yes, we understand, just the issues to get them through closing, but then we also handle so much more. That's getting them the tax IDs and handling disagreements with the IRS and getting the money back for the foreign sellers. And then when there's a penalty comes up, we'll get the buyer out of those if that should be an issue. So
That's
yeah,
great.
20 years.
Like
yep.
a lot of experience, and probably a really good friend to have if someone's going through some of this in their transactions. So, for those who are new and really maybe they've never heard of FIRPTA or don't know what it stands for, can you just help to educate the audience a little bit? What does that mean, FIRPTA?
Sure. So FIRPTA, the Foreign Investment Real Property Tax Act, FIRPTA, has been with us since the 80s. This is actually a law, was an act. Congress sent this up to the White House, was signed off by the president, signed into law in 1980. And the Foreign Investment Real Property Tax Act came about because foreign people were coming to the U.S. They would purchase U.S. real estate. Maybe they turn it into a rental property. And along the way, it would appreciate in value. And they'd be collecting rental income along the way, but for some reason, interesting, they'd come from a foreign country where they have an income tax, but they'd get here to the U.S. and they would develop amnesia. They don't know what taxes are. They would forget all about it. They collect the rental income along the way. Property would appreciate in value. And then one day they'd decide to sell. So they'd sell the property. They'd pocket 100% of the proceeds. They'd leave, the money's left the U.S. and foreign seller would say, catch me if you can, when it comes time to settling their tax affairs. Well, if a U.S. person did that, if you or I did this, the IRS, they know where we live, they know where we work, they know where we bank, and they know where the property is, right? So they're going to catch up with us. So in order to level the playing field on this, the government came up with this one-size-fits-all program called FIRPTA, right? And if we know anything about the government, not terribly efficient, and if it's a one-size-fits-all, it's not going to fit anybody, and it's really not going to be very convenient either. So FIRPTA is simply, it's a deposit It's not a tax, even though, interestingly, the IRS refers to it as a tax. It's not a tax, it's a deposit. So instead of the money sitting in escrow with the title company, 15% of the contract sale price is going to go on deposit with the U.S. Treasury, better known as the IRS. It's going to sit there with the IRS until the foreign seller files a tax return to report the property sale, and they clean up their federal affairs with the U.S. government. The federal tax affairs are cleaned up, and then net of tax owed on the property sale and any other unsettled federal tax matters. Once that's all cleaned up, net of that, they get their money back. And typically, if the foreign seller has been playing by the rules, reporting their rental income along the way, if that applies, there typically is very little, if no tax, and they get all of that deposit back.
Okay.
So it's not the end of the world, but it's certainly not a welcome surprise at a closing. So
Sure.
if it's a surprise at the closing table, there's ways we can mitigate this, because reality is the foreign seller doesn't know the first thing about U.S. tax, and the buyer doesn't know the first thing about foreign tax. And it's this big mysterious thing, and everybody's upset. And all seller hears is, hey, I'm being charged 15% because I'm not from around here and nobody told me. It's my realtor's fault. It's this title company's fault. And they're just discriminating against me because I'm not a U.S. citizen. And all the buyer hears is IRS is coming after me for 15% plus penalties. And so now you got both parties wanting to back out at the closing table.
Yeah, I bet.
When the reality is, seller, it's not a tax, it's a deposit. You'll see the money again. You've just got to file a tax return, which you normally have to do in your home country. So this shouldn't be any new mystery. They may not be happy about it, but it's the reality. It's a tax law, but they'll see the money. Yeah, they'll see the money again. For buyers, there really is no risk. I mean, buyers think there's a risk, and everybody tells, oh, you could have the IRS coming. The reality is, as long as that money's withheld at closing, sent in within 20 days with tracking, there's no risk. Even if the check gets lost, check can get lost. I've had this happen. It's no problem.
Yeah.
Just issue another check. All I have to do is prove up that the first check went out within the 20 days with tracking, and there's no issue.
Okay. Good to know. I'm sure there's a lot of, reasons for there to be nerves on both sides of the transaction there. So it's good to hear some reassurance that, it doesn't have to be all that bad or that intimidating, but it sounds like you do need to know what you're doing and then do it right, so to speak.
And if it helps, there's even some Treasury regulation carve-outs that protect the settlement agents. So the closing attorney, and depending on which state we're talking about, in some states they're referred to as closing attorneys. Some places they're escrow officers. I use the generic term settlement agents because that's what the IRS refers to in all the Treasury regulations. But settlement agents, escrow officers, title company, closing attorney, they're protected by the regs as long as they're performing settlement agent duties. Now, that means they're not giving tax advice, they're not preparing tax forms, and that's fine, and then they're covered. And so there are some protections in there. A lot of people look at title, or the closing attorney or the settlement agent like, they're the know-all be-all, and they're going to give us all the answers when it comes to FIRPTA. And no, that's really outside the scope of what the settlement agents are supposed to be doing. But if they have questions, they don't have to do this on their own. They can call us and we can help. Now, believe it or not, the parties who are on the hook for this, of course, it's the buyer who's ultimately responsible. But the buyer's agent is always also sitting right there next to the buyer. So buyer's agent's also on the hook for this FIRPTA, and a lot of realtors don't realize this. Now, their exposure is somewhat limited to the amount of commission that they get on this, but if the buyer gets nailed for, say, on a $500,000 sale, it's a $75,000 withholding that was supposed to happen and didn't, and then penalties are accruing at 5% per month, and then every 30 days thereafter, starting on day 21 post-closing. Yeah, that buyer has a cause of action against their realtor for failing in due diligence to inform buyers. So
very
their
important.
exposure to IRS may be limited to the commission, but it doesn't mean that it's limited, the exposure is limited to, their client. So they have a due diligence requirement to inform themselves of FIRPTA and how it works. And again, they don't have to do it themselves. They can just call us and we can help.
Get some help. So is this something that realtors are taught about in their training? How do realtors know?
I can speak to the state of Texas. Now, I don't know
Okay.
about all the other real estate age or compliance organizations out there for the different states, but I know here in Texas, FIRPTA is something that's it's taught in the school, and it's also a continuing education topic. We teach a 1 hour continuing ed class for CE for realtors, FIRPTA for realtors, and what do they need to know so they don't have a compliance failure. Other states I know have this. I just couldn't name every state that does and every state that doesn't. But so far in most states in their real estate contract, I see there is a paragraph dedicated to FIRPTA.
Good. Okay, good to know. So there are steps along the way where people should have been, clued in and notified that this was, something to pay attention to.
But now that said, even if it's not in the real estate contract, especially I see this in commercial real estate contracts, a lot of times FIRPTA is not touched. But just because it's not in the contract doesn't erase it from the federal tax compliance requirements. Right. So it's still there, it still exists, and it's still a compliance requirement, even if it's not in the real estate sale contract.
Okay, good to know. Good clarification. So one of my questions, Mark, is how do you think listing agents should address this issue at the time of listing? What's the best way to handle it up front?
The best way to handle it up front would be so the listing agent, I'm sure they have a list of questions that they have for their sellers. Seller wants to sell a property and they find a realtor who wants to take the listing. Great. Well, they should, from a due diligence standpoint, have a checklist of questions that they ask. And I know the listing agreement here in Texas specifically asks the question, seller is or is not considered a foreign seller. If you're the listing agent, and even if your real estate association doesn't have this in the listing agreement, you should still ask this question, and here's why. It's still a federal tax requirement. It's still going to come up at the closing, and closing is not the time for surprises. Surprises is not a fun time at the closing, so you want to ask the question, and some people are uncomfortable asking the question. They're like, well, I really don't want to ask if they're foreign or not. You know what? It's a reality. It's a tax law, and don't be embarrassed and don't be shy. You can tell them, look, this will come up at the closing, and you're going to be asked to sign a certificate of non-foreign status. It's an affidavit that simply says, this is my name, this is my address, this is my U.S. tax ID number, and I'm going to have to swear under penalty of perjury that I am not a foreign seller, subject to FIRPTA requirements. And that should be disclosed to the seller at the time of taking the listing. Because there's also an important question that the listing agent really should ask. It says, hey, if you're considered foreign, there's going to be 15% of the contract sale price withheld. Is that a problem? And, nobody wants money withheld. But if there's a mortgage that's up to here on, say, a $500,000 property, and the mortgage is $450K on a $500,000 sale, well, FIRPTA 15% is going to be 15%. That's $75,000. So if forget about other closing costs. Let's just talk about the mortgage. If it's selling for $500 and the mortgage is $450, and FIRPTA is $75, seller's now going to have to bring their checkbook to the closing table to make up that $25,000 shortfall. And we haven't talked about closing costs yet, which are probably going to be around another $40K. So if that's the case, boy, you sure don't want that being a surprise at the closing table.
Surprise, right. So it sounds like the burden of responsibility. Oh, sorry, go ahead.
Oh, yeah. There is a way where they can maybe reduce the amount of withholding that's required. So if the listing agent's aware of this, when they take the listing, they can have this talk with their seller and say, hey, look, if this is important to you that we reduce the amount of FIRPTA that's withheld, again, remember it's a deposit. They'll see the money again. But if it's important to them because of, say, like a mortgage, or they just need as much proceeds as they can get for whatever reason, they could say, hey, look, if we limit ourselves to the universe of homestead owner occupants, or a family member of buyer is going to occupy the property, if we limit ourselves to that universe, in other words, not first come, first serve and highest one wins, but we only want owner occupants, or at least a family member of the buyer is going to occupy. If the buyer will sign an affidavit of intent to occupy, that they're going to live there for at least 6 months of each of the next 2 years, and the buyer is willing to sign an affidavit that states so, with an acknowledgement that says if IRS determines the affidavit is false, the IRS can then go after the buyer for that 15% plus penalties and interest. So they really have to treat the property like a homestead, or at least a family member. Parents could buy a condo for the child attending university. That's fine, because they're going to be there for at least 6 months of each year if they're attending university for at least 9 months a year. So if they're going to occupy for at least 50% of each year for the next 2 years, and they sign that affidavit of intent to occupy with the IRS acknowledgement, then we can look at the sale price. If the sale price is $300,000 even or less, FIRPTA is eliminated. It's exempt. So if the sale price were $300K, of course the buyer is going to occupy. That's the first question: is the buyer going to occupy, or a family member? And then is the buyer going to sign? If those two are true, then we can look at sale price. 300,000 or less, FIRPTA is eliminated. Put it in the closing file. We're done. If it's 300,000 and $1 up to $1 million, and the buyer is going to occupy, buyer will sign, we can reduce it from 15% down to 10%. 10% is still a big chunk of money, but on a $500,000 sale, we reduced it from 75,000 down to 50,000, and that may just be the amount to get them over the hump with the mortgage payoff and the equity in the deal, where maybe the seller doesn't have to bring money to the closing table. And again, remember that deposit is refundable when they file their tax return, net of tax that's sorted out with the tax return next year. So those are some of the exemptions that may be available. So that might soften the blow. Now, if, like I was saying with the listing agent, if this is important to the seller, they would want to make this a special provision in the real estate sale contract, because now they have an enforceable provision in a contract. Contract offer acceptance, valuable consideration. They're past the option period. Now you've got an enforceable provision in the contract. Absent that, the buyer can still sign that affidavit of intent to occupy. But I've also had buyers who, at the 11th hour, at the last minute at the closing table, they said, I changed my mind. I don't want to sign it. And, again, this is horrible for the seller, because the seller thinks they're getting X, and now they're getting X minus Y. They're getting quite a bit less. And so you cannot ever force a buyer to sign that affidavit of intent to occupy unless it was a special provision in the contract. Otherwise, they're just relying on the buyer's goodwill and in the spirit of getting the deal done. But the buyer can always change their mind at the last minute, and there's nothing anybody can do about it. I had one where sellers promised to pressure wash the driveway and get the oil stains out. And buyers drove by on their way to the closing, and they didn't do it. And then the buyers said, not signing that affidavit. Tough. And so all of a sudden, now the sellers are having 15% withheld, and for $150 pressure wash job, they could have avoided all this.
Avoided that. Wow, that's a good perspective. That's good to hear those kind of stories. I hope it'll sharpen people to be a little more wise when they're faced with a similar decision.
So the takeaways there are: listing agents, ask the question at the outset. It's important to talk about this, and if it's important to your seller, have that talk with them and have a talk with your broker. And maybe you write that special provision into the real estate sale contract. And it's more to it than just a homestead. Okay, there's some special language that needs to go in there. Give us a call if you need help with that. But if it's a special provision, now you've got an enforceable provision in the contract. Absent that, just know that you're going to be saying pretty please, and you're going to hope that the buyer cooperates at the closing. And the buyer doesn't have to. You can't make them. I mean, the
Gotcha.
moving truck can be in the driveway, and the whole reason they bought that house is because of the school district, where the children are going to go to school for the next 6 years. They meet all the elements, and buyer can say, I don't like the color of your shoes, or the cut of your jib, but I'm not signing. Nothing you
Yeah,
can do.
yeah. So it definitely comes with some risk. Thank you for explaining all that. I think you touched on this a little bit, but are there any other exemptions to the FIRPTA tax that you would want to mention or recap for us?
So the big one is the first exemption, the biggest one is we've got a U.S. buyer. So if it's a U.S. person who's buying, it's going to be exempt. What's a U.S. person? Well, a U.S. person might have a U.S. birth certificate, U.S. passport, could have naturalization docs, or they might have a long-term permanent resident visa, also known as a green card, right? Those are all considered U.S. persons. And there's a fifth one, someone who meets the substantial presence test. They've been here in the U.S. long enough. They have a tax ID. They're playing by the rules. So those 5 categories are all considered a U.S. person, and they're exempt, right? All they have to do is sign that certificate of non-foreign status. It's simply an affidavit that says, this is my name, this is my tax ID, here's my address, and I'm exempt, and I'm signing this under penalty of perjury. And you can accept that on its face. Okay, if the seller is willing to sign that, the buyer can accept it on its face, and the buyer has no duty to audit or otherwise examine the certificate of non-foreign status, unless there's conflicting facts. And oftentimes what will happen is, initially, seller will say, oh, yeah, I'm a U.S. person. No FIRPTA for me. Or maybe no, they don't even hear about FIRPTA, right? They just say, well, yeah, I'm a U.S. seller. That's fine. And they don't even think about it. And then say, well, actually, I don't know, am I U.S. or not? I'm from a foreign country. I'm not a U.S. citizen. So yeah, okay. So no, I'm not a U.S. seller. Okay, fine. So you hear that, but nobody says FIRPTA and withholding to them. And then you get to the closing and you find out, well, yeah, seller's in a foreign country. They don't have a tax ID. We're doing a remote closing. They're at the embassy in XYZ foreign country. And then they hear about this 15% withholding. So the night before, they do some reading and they go, oh, all I have to do is sign this self-serving affidavit that says, I'm not foreign. I'm a U.S. person. And so they try signing it. And I've had them sign it with no tax ID, and they list a foreign country for the mailing address. And I'd take one look at it. I'm like, no, there's no way. You've got all these conflicting facts. And I tell, buyers will ask me, can I accept that? Like, no, you can't. And so if there's conflicting facts, then somebody's going to have to sort it out and figure out, where's the conflict and what's the disconnect here. But if there's no conflicting facts, you can accept a certificate of non-foreign status on its face. But if there are conflicting facts and you've got this mountain of evidence that says, hey, I've got a foreign seller, and at the 11th hour, they come in with this self-serving affidavit, if you close your eyes to all those conflicting facts in favor of that self-serving affidavit to get the deal done and get it over with, you might be accused of engaging in a concept known, it's a legal term, willful blindness. You can't engage in willful blindness, close your eyes to all these overwhelming, all this overwhelming evidence that says foreign seller in favor of the self-serving affidavit without sorting out the conflict. And so if you did do that, you could expose yourself to penalties. So you'd want to be aware of that. But absent that, if you have no reason to believe they're foreign and they simply signed the certificate of non-foreign status, they filled it out properly, it's not hard to fill out. It's a W-9 essentially, with an acknowledgement that if the IRS determines the affidavit is false, that then, the IRS can go after the seller and the agent for seller. But if they sign that, the buyer can accept it on its face, and they have no duty to audit or otherwise examine, nor does the realtor for buyer, realtor for seller, or title. Nobody has a duty to audit or otherwise examine the certificate of non-foreign status. You can accept it on its face. If the seller wants to commit tax fraud, that's between the seller and the IRS.
All right. Okay. Do you know, Mark, can a realtor lose their license if they're not doing their part to educate a buyer or seller?
I don't, I'm not an expert on the relationship between the realtor and their professional association and the regulatory body, but I do know that they have a due diligence be aware of all the legal responsibilities for the client that they represent,
Yeah.
right?
Okay.
They're acting as an agent. So due diligence, right, is a legal responsibility to be informed and inform your client when buying or selling something. And so there's a known legal duty and they fail to inform their buyer or seller and saying, I didn't know, right? That's not going to get them out of it. They've got a due diligence.
Yeah.
They've got a responsibility to be informed of the law as they represent their client. And so it exposes them on two fronts at least, maybe a third front, exposes them one with Treasury and the penalties there,
Mm-hmm.
limited the amount of their commission. And then the poor buyer is going to get nailed for this.
Right.
And so it exposes them to, the buyer's got a cause of action against them. And then, of course, that could also bring sanctions from the regulatory body, their agency that licenses them. And so could they lose their license? Maybe. They certainly stand, it exposes them to some risk and sanctions. Does that
Yes.
result in license forfeiture? I don't know if it's going to rise to that
Gotcha.
level, but
Right.
it certainly exposes them to some risks.
I will have to ask a few agents and see if they've ever run into that or heard stories of, maybe someone not following through as they should. So I appreciate your perspective. So my next question is, are there special regulations for domestic companies owned by foreign individuals? So it's a US company, but a foreign owner, how does that play out?
Speaking to FIRPTA only, okay, there's lots of other requirements that happen when there's foreign ownership of a U.S. entity. It depends on what kind of entity, all right? And so I'm going to bring up a term here. It's called, and I'm not trying to get deep in the weeds here, gang, but I just want to
Okay. Right.
clarify something. You're going to hear a term called disregarded entity. And you may hear a term called single member LLC or sole member LLC. Sometimes you'll see it written as SMLLC. So sole member limited liability company. A limited liability company is a state level entity. And what that simply means is it's recognized by the state, it's set up within the state under state law, but the federal government is pretty much going to disregard it. Okay, disregarded entity. What they're going to do is they're just going to look through it, pretend it doesn't exist, and they're going to say, hey, who is the ultimate beneficial owner of this entity? And if it's an individual, okay, well, now it's going to be up to the individual and their tax residency status. And if that person is a foreign person, well, now we're right back to FIRPTA. So you could have a person from a foreign country come to the US and set up a state level single member LLC, limited liability company, which is a disregarded entity. And the federal government's going to disregard it. They're going to look right through it and, hey, who's the ultimate beneficial owner? And that the residency of that ultimate beneficial owner is what's going to determine whether or not FIRPTA applies. And so, and I've said a whole bunch of stuff here and people's eyes are glazing over. Let me just boil this down. Let me make disregarded entity super simple. Mark, how do I know if it's a disregarded entity or not? Simple. Here's a really simple test. Does the entity file its own standalone tax return from the individual?
Okay.
If the entity files its own tax return, meaning we all file a Form 1040 every year, right? We're individuals. We all file a Form 1040 with the IRS. We should all be aware of that. We understand that. Okay. And if we're realtors, we file a Schedule C, and that's just self-employed, right? So the self-employed person files with a Schedule C, 1040 with a Schedule C. If they have rental property, it's going to go on Schedule E, right, on the individual tax return. Okay. If the entity files its own tax return, not a 1040, but like a 1065 for a partnership or an 1120 for a corporation, great. It's filing a separate tax return, it's not disregarded. The federal government regards it because it's a 1065 partnership or an 1120 corporate return. But if they disregard it and they look through it at, hey, who's the ultimate beneficial owner? It's you individual, and you're reporting this on your Schedule C or your Schedule E. Now it's a disregarded entity. So a disregarded entity cannot sign an entity seller certificate of non-foreign status. It's question number 2 on the form. It says, and I am not a disregarded entity. Well, there you go. So if it's a single member or sole member LLC selling, guess what? It's going to have to be signed by the individual. So now it's not going to be on the entity seller. It's going to be on the individual certificate of non-foreign status. And if that individual is foreign, well, now they can't sign it because they're foreign, and now we're right back to FIRPTA. So the short answer of all this, it took me a long way to get here, right? If a foreign person creates a U.S. LLC and has that LLC buy property, great. You've got a state level U.S. entity that's disregarded. We don't care that you have an LLC. We're going to look through it, who the ultimate beneficial owner is. And if you're foreign, you're right back to FIRPTA. So all you did was FIRPTA with extra steps.
Yeah,
extra money.
They created more work for yourself. Okay, good to know. Good explanation. Thank you.
Was that clear, or was that too long-winded for you?
I think so. Yeah, I was able to follow you. So good insight. My next question is, does FIRPTA apply if one of the title holders is a U.S. citizen?
Okay, that's a really good question. So what we are going to look to is who acquired the property,
Okay.
and how much skin in the game does each acquirer of property have. And so if, U.S. person marries a foreign person, and U.S. person lives here in the U.S. and foreign person lives in foreign country, okay, and they buy property together, right? So they buy it 50-50. Okay, well, when they go to sell, 50% of the allocation is going to go to foreign person times 15%. The other 50% is going to go to U.S. person exempt from FIRPTA.
So one of them would be held accountable for the FIRPTA.
On their allocated percentage.
Okay.
So here's one. I had a couple of sisters purchased property here in the U.S., and they were living in the property. And then one of the sisters married a gentleman from foreign country. Okay. And that person, he couldn't come to the U.S. because his parents were ill. And so he's living with the parents in foreign country, taking care of them. They're elderly. Fine. The sisters decide to sell the property, and we're in a community property state. And so title right away adds, they ask the question, hey, are you married? Yes. Boom. The name of the husband, and then they add the husband to the real estate transaction. But he didn't pay anything for the property. He didn't pay any property taxes, maintenance, or upkeep along the way. But technically, he's at the table for FIRPTA until we determine that he didn't pay anything. So he's got no contribution to the property. He didn't pay for the upkeep, and he's not taking anything from the proceeds. So we drafted an affidavit that stated, I didn't contribute to the purchase, I didn't contribute along the way, and I'm not participating in any of the proceeds. And we had each of the sellers added to the settlement statement as a line item, and his proceeds showed zero. And then there's a specific carve out in the regs that shows that if they're not getting anything, then they're exempt.
Nothing to pay in advance on.
or technically they're subject to 15% times zero, which is still zero. So there is no FIRPTA on that foreign seller.
Really interesting, unique circumstance for sure. I'm sure you've seen it all and run into it all at some point in your career.
Now, here's the popular dodge. Here's what happens. Here's what I see happen all the time. Husband, wife team, they acquire the property, and wife's off in the foreign country. She's left the U.S., not a U.S. tax resident. And they go to sell, and then they say, oh, well, we're going to allocate everything to the U.S. spouse. And the regs specifically say you can't do that. If you get caught doing it, you're avoiding FIRPTA, and that triggers that $10,000 penalty. So you wouldn't want to do that. So yeah, it's the allocated percentage is how it's going to get divvied up. And I see this happen a lot. Sometimes I'll have a person will pass away, and then the children, the heirs, will inherit. And some children will be U.S. and some children will be foreign.
Right. Wow.
And then it depends on what happens. If the property is inherited by the children and it's split, say, 3 ways amongst the children and the children sell, now we've got FIRPTA. If they slow down and let the estate sell the property and it was a U.S. decedent and it's a U.S. estate, now there's no FIRPTA because it's a U.S. seller as the U.S. estate, and then the property can be distributed amongst the heirs. So it really pays to talk to somebody who understands FIRPTA and what's going on before they just, sometimes they call me up and they want me to put the cow back in the barn after it's escaped. You know, once the deal's done and the year's over, there's not much I can do.
Yeah. Good to know. All right, my next question. What is substantial presence?
The substantial presence test is how we can figure out if someone's a U.S. tax resident or not.
Okay.
So there's several elements to the substantial presence test, and not in any particular order, but in my opinion, I think one of the more important elements is that the person is not here in the U.S. on an exempt visa status. And it's sort of a backwards way of looking at something. Exempt visa status simply means that they're on a visa where their days of presence don't count. Most popular example that I can think of is an F1 student visa holder. Never ceases to amaze me how many students have enough money to buy property while they're going to university. When I was going to university, I didn't have any money either. But I've got students who come here to the U.S. and they'll buy property. You know, they'll buy a condo that they're living in while they're going to school. Okay, fine. Well, even though they're going to university for, say, 4 years, and one of the elements of the substantial presence test is being present in the U.S. at least 183 days, according to a formula. And you can meet that in 1 year or over a number of years according to a formula. And 183 days is simply half of a year. So 365 days in a year, cut it in half, what do you get? 182 and a half. Once they set foot into that 183rd day, they're substantially present.
Okay.
Going back to the first day of the year that they were present in the U.S. Okay. But there's more to it than that. So first, they have to not be in the U.S. on an exempt visa, like an F1 student visa. And there's a number of them, an A, D, G, F, M, or Q visa. Those all could be exempt. So we really have to look at it. And that's beyond the scope of what a realtor, title company, closing attorney, escrow officer, settlement agent are required to do. So if there's questions on it, you can call either an immigration law firm, get them involved, or give us a call and we can help. We can answer that question. But first question, are they here on an exempt visa? If the answer is no, well, let's say they're here on no visa at all. I've got people who came here 5 years ago on vacation. They liked it so much that they're still here. So their 90-day tourist visa expired. They're still here, and maybe they're skilled in the trades and they went into business for themselves. And there is a lot of people here in the U.S. like that. And they may not have legal immigration status, but as far as the IRS is concerned, they're U.S. tax residents, provided
long-term presence,
provided they're playing by the rules, right? So they would have to meet the substantial presence test. And when I say playing by the rules, functionally what that means is they're going to have a tax ID and filing a U.S. tax return every year. Now, I might have some lawyers argue with me over that, like, Mark, that's not what the substantial presence test says. Well, at the end of the day, if they don't have a tax ID, we can't prove up how long they've been here. How are they going to sign a certificate of non-foreign status? So we get some that are flying under the radar, so to speak. They're not paying any U.S. tax. But those are the people that FIRPTA is meant for. So they're going to put that deposit in, and then they're going to have to get with the program, start playing by the rules, and they can get the money back next year when they file their tax return. Welcome to the United States. And they're going to have to start playing by the same rules that you or I and everybody else has to play by.
Mark, can you speak a little bit to the timeline? We were talking a minute ago before this recording, and we were sharing why it can be more beneficial to close, at the end of the year versus January 1st, and how does that really affect someone in there?
Sure. So right now we're, real estate kind of slows down in the fall, but we always get this bump at the end of the year because we've got people running for the exits. Because if they understand anything about FIRPTA and they know that it's a deposit, it's not a tax, they can get their money back when they file the tax return to report the sale, and they understand that the tax return is filed April 15th or by April 15th of the year following the year of sale. So let's say you've got a closing happening right now, let's say December 15th of 2024. It's $500,000. Okay, fine. 75,000 is going to be withheld. It's going to get sent off to Treasury. Well, when they report that 2024 real estate transaction in 2025 and report it on the tax return that's due by April 15th of 2025, they can recover that money probably by around April next year. So the money is going to be tied up for about 120 days or so. If the closing is delayed for who knows what, I don't know, but gets delayed till January 3rd of 2025, and now it closes. Well, that 75,000 is still going to go in, but they're not going to see that money again until sometime around April 15th, 2026. So now they got to go all the way around that calendar till April 15th of the year following the year of sale. Report the property sale, and that's when they can recover their money. So my advice is, if you're going to sell and you're foreign, get it on the market, get it listed quick. Otherwise, you may be waiting a while unless you qualify for one of those reductions.
Yeah.
And there is one other way where they can maybe get out of FIRPTA, and that's something called a withholding certificate.
Okay.
A withholding certificate is just an application that says, hey, IRS, 15% is a lot of money. And you know what? Based on the gain that I have here, it's way more money than really realistically needs to be withheld. So pretty pleased with sugar on top. Would you see your way to reducing the amount of money that's going to be withheld? Let's say they bought it for $600,000 last week. It's an extreme case, and they just realize, like, man, this property is all beat up and it's got all kinds of problems, and I don't want to put more money in, so I'm going to sell it this week. So they bought it last week for $600. They're selling this week for $500. So they've lost $100,000. Clearly, there's no tax due, right? Lost $100,000. Well, if they're foreign, I got bad news. 15% of the contract sale price has to be withheld. So they're still stuck with that $75,000 withholding, even though they lost $100,000 on the deal. If they have no other federal tax liabilities, they're going to get all $75,000 back next year. Well, if they apply for a withholding certificate, and we can prove this up to IRS, IRS will say, oh man, that's unfortunate. Paid $600, selling for $500. Yeah, we're gonna say no FIRPTA, no money, nothing to be withheld. That's great. Here's the problem. It's the IRS, and they're a little behind. They're a lot behind. They're so far behind, it's ridiculous. They're about a year to 16 months behind on issuing withholding certificates. So just close now and get your money back in April instead of going around the sun a lap or two before you see your money again.
That's interesting. Yeah, another good insider tip that most people wouldn't know unless you're in the know.
Now, if it's a hardship, okay, in other words, they're going to lose the house to foreclosure and they really need the proceeds, get a little bit of equity out of it, they can. If it's a hardship case and I can make the case to the IRS, I may be able to push one through in about 60 days. But that's in a case-by-case basis and only in hardship scenarios. But we work so much with the IRS in Ogden, Utah, in the FIRPTA department that I'm not going to say I know anybody there. I've got a bat phone number where I can call, but we're familiar enough with the department that we may be able to push a deal through in somewhere around 60 days, but only in certain specific cases if it's a hardship scenario. Otherwise, they're going to have to get in line like everybody else, first in, first out. Plan on at least a year before they see that withholding certificate again. Typically, I don't see withholding certificates unless it's real estate sales that are up in the millions. More than $1 million starts becoming, maybe it's worthwhile to do, or if it's a transfer between parents and children.
Okay, that makes sense.
If mom and dad are going to transfer their property to an adult child, and let's say the U.S. adult child's living here in the U.S., they're going to live in it. There's no hurry, to get the deal done. So we can apply for a withholding certificate. Maybe the child's going to buy it from the parents. There's some tax strategies there where maybe we can get them out of it as well. Certainly don't gift it. Absolutely, that's a bad idea, a foreign person gifting it. but
Okay.
we may be able to do a transfer, and then later on, maybe there's a cancellation of debt, and that may work and avoid FIRPTA altogether. That's sort of an advanced strategy, but that can work, and that's where a withholding certificate might work well because we're not really in a huge hurry to get the deal closed, and we can wait. And once the withholding certificate shows up, then we can go to closing, and then no money needs to be withheld. If that makes sense.
Advice. Yes, thank you. So my last question is, how do you see the future of AI affecting the industry? Will it change anything in your world?
I don't think it's going to change anything right away. FIRPTA is sort of the backwater of the IRS. It's a small enough niche compared to everything else. I think they've got bigger fish to fry is sort of a simple way of saying it. So, and one cue to that is FIRPTA is still a paperwork driven department. It's all paper up there. It's not electronic. Like when you file your tax return, you know, you might be doing that from TurboTax from your desk at home, you know, and you can sit there and have a cup of coffee and do it, and it's not a big deal, and you just do it yourself. And AI is helping you through all that. FIRPTA, it's all paperwork driven. And so they haven't even made FIRPTA electronic yet. So eventually, I think AI is going to put me out of business, but I don't think it's coming anytime soon.
Good to know. Mark, is there anything else you want to say before we wrap it up today?
Yeah. FIRPTA, you know, we make FIRPTA easy. You don't have to do this yourself. And you can call us. We'll be happy to answer questions. If you've watched this podcast, just say, hey, you watched the podcast. Tell us how you heard about us. And we're happy to answer questions, and there's no cost for it. If it turns into a consulting job, you know, where we actually have to do work, consulting engagement, typically it's the seller who winds up hiring us, because if seller wasn't foreign, we wouldn't be talking. Sometimes sellers are a little bit obstinate and they'll dig their heels and like, nope. I read there, it says buyer's obligation. And so, you know, we're not paying for this. So, okay, you know, that's fine. Once I explain to them like, hey, look, it's not seller's money. It's not buyer's money that's on the line. It's your money. Yeah. So if you want the buyer cheaping their way out and filling the forms out with a crayon or not filling the forms out, you know, that's up to you. We're getting the lowest bidder to do it. But just remember, it's all your deposit that's on the line. If it's not done right, you might not ever see that money again. A lot of times sellers will have a change of heart and be like, yeah, you know what, maybe I do want to be driving the bus here. Yeah. You know, so I'll go ahead and hire you after all. But, you know, if they say, hey, you know what, I got my own tax guy and we're going to foist this off on the buyer, that's fine. Buyer may not be as inclined to sign that affidavit of intent to occupy, you know, if he's getting saddled with compliance burden and cost. So, but if buyer does it, you know, we'll be happy to do it for the buyer as well. And, you know, we can do just the compliance work. But either way, whether we do it for the buyer or for the seller, if we're involved in the transaction and we prepared the documents, if something ever should go wrong, even if seller hired us, we'll still take care of the buyer. And we're not going to say, hey, buyer, you know, you didn't hire us, so you're on your own. If something goes wrong, because we deal with this so often and we know which department in the IRS is dealing with this and how to deal with the issue, we'll just take care of the buyer and we won't charge them anything. We just fix it. And it's not because I'm a great guy, but it really buys me a lot of goodwill with the title company and with the realtors. And we tend to get more repeat referrals if we just clean stuff up after the fact, even though it's not our fault. The screw up may have had it happened at the IRS end, which is usually where it happens. We just clean it up.
Okay. And what's the best way for someone to reach you if they're interested in that consultation or learning more?
Sure. A real simple way to do this is go to GOT-FIRPTA, so GOT-FIRPTA. So the word, remember the old Got Milk commercials from the 90s?
Yeah.
This is, I'm not proud, okay, and I'll admit it. It's a shameless ripoff.
I think it's clever.
I'm just ripping off the Got Milk commercial. So we've said GOT-FIRPTA, and then we've got some explainer videos that explain what is FIRPTA, and it's really made for buyers, sellers, and for the realtors. And we even do it in a couple of different languages, Spanish, and then a couple dialects of Chinese, Mandarin, and Cantonese. Great. But if you need a French speaker, Arabic speaker, Vietnamese, call us and we can get somebody to explain things to your buyers and sellers as necessary. But if you go there, you watch the video, that'll explain, it'll demystify a lot of this. And hey,
Right.
realtors, you can use this to explain it to your buyers and sellers so you
Right.
don't have to try and re-explain it to them. And then give us a call. You can ring us up and we're happy to answer questions. And again, the staff, we all speak Spanish if needed. And if you need to get Mandarin or Cantonese, give me about a day and I can line that up. We've got some staff that can do that as well.
Right.
And we'll answer all your questions. And then if we need to do work, pricing is up front. It's flat fee pricing. And once they know what the price is, then they can either say yes or no. If they say yes, we send them an engagement agreement for the consulting work. Once they've signed it, we do the work, and then we can get paid at settlement. And then if the deal, for whatever reason, should fall apart, there's no risk. We just eat the cost, and we'll wait for the next one.
Well, Mark, thank you again for your time. I've learned so much today, and I know our audience has as well. Thank you.
All right. Thank you so much, Janis. And anytime you have questions, please give us a call. We're happy to help.
We will. Thanks so much. Bye-bye.
All right, then. Bye-bye.